The last part of the American experiment focuses on the Bill of Rights. Previously, we've seen how the framers spent considerable time and thought on crafting a system of checks and balances in the body of the Constitution. That still wasn't enough to persuade all of the states to go along with the move from the Articles of Confederation to the Constitution. So the states required a Bill of Rights, or the first 10 amendments to the Constitution, that would protect individual liberty, would protect individuals from the abuses of the federal government. And so in this section, we're going to focus on the limitations placed on the federal government by the Bill of Rights. The Bill of Rights did not come from the Bible. Rather, it came from the framers' experiences as Englishmen with their English history, and also from Enlightenment philosophy. The European writings, intellectual thought of the time made it into our Constitution. So we start with the Bill of Rights in 1791, and the first of those amendments focused on liberty of conscience. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peacefully assemble and to petition the government for redress of grievances. These were all ideas coming straight out of the European Enlightenment of the 18th century, promoting individual liberty over the authority of a king or a monarch or a church to restrict people's thought. Now, this is directly contradictory to what the Bible says about freedom of religion and freedom of speech. So you can look at Deuteronomy 7, 1 through 11, for example. When the Lord your God brings you into the land you're entering to possess and drives out before you many, 7 nations and larger and stronger than you, and when the Lord your God has delivered them over to you and you have defeated them, then you must destroy them totally. Make no treaty with them and show no mercy. Do not intermarry with them. Do not give your daughter to their sons, or take their daughters for your sons, for they will turn your sons away from following me to serve other gods. And the Lord's anger will burn against you and quickly destroy you. This is what you are to do with them. Break down their altars, smash their sacred stones, cut down their Asherah poles, and burn their idols in the fire. For you are the people holy to the Lord. The Lord your God has chosen you out of all the peoples on the face of the earth to be his people, his treasured possession. So here we see in Deuteronomy the law established in the Bible that as far as religion goes, there was no tolerance, no acceptance of any religion except the religion of the Hebrews. They were to drive out other people. So this was not an argument for diversity. It was not an argument for freedom of speech, freedom of the press. This was clearly that God had laid down the laws, and anything that contradicted that could and should be driven away. The First Amendment makes sure that religion and the press and speech and assembly to criticize the government for changing laws, all of those rights were secure so that individuals had the liberty of conscience. They could think, they could speak, they could petition their government if they didn't like the way things were going. The Second and Third Amendments focus on war. The Second Amendment, a well-regulated militia being necessary to secure a free state, the right of the people to keep and bear arms shall not be infringed. The concern here was that the federal government could now have an army, and there was nothing in the original Constitution talking about state militias, and so this Second Amendment made sure that states could have a well-regulated militia. Unlike the First Amendment, where it says Congress shall make no law, this Second Amendment clearly states about a well-regulated militia, regulations coming both from the state and the federal level. Third, Amendment, no soldier shall in a time of peace be quartered in any house without consent of the owner, nor in time of war, but in the manner prescribed by law. This too is taken directly from the English Bill of Rights, which dealt with the quartering of troops. We saw earlier how the quartering of troops was a factor that aggravated the colonists. So the Fourth and the Fifth Amendments focus on suspects' rights, people who are suspected by the government of committing a crime, but there has been no trial yet. It was common practice for monarchs and churches in the early modern era and pre-modern era to simply address people, throw them in jail, and not provide them with a chance to defend themselves. The Fourth Amendment protects an individual against unreasonable searches and seizures. The people have a right to be secure in their persons, houses, papers, and effects. That if a government wants to search a person suspected of a crime, they must have probable cause. That probable cause must be supported by an oath or affirmation. So someone has to have a reason to do this. They just can't have a feeling in their gut. Have to have some type of evidence beforehand before something can be searched. And then the Fifth Amendment says no person shall be held for a capital offense. Capital is a head offense where you can lose your head, have your head chopped off, be killed. No person shall be answer for a capital offense, otherwise infamous crime, unless presentment or indictment of a grand jury. So a grand jury is a pre-trial jury that looks at the evidence to make sure that the government has reasonable suspicion. If the grand jury, a jury of your peers, do not believe that the government has reasonable suspicion, then the grand jury can deny an indictment, and the prosecutor must wait until they have enough evidence to convince a jury that they could reasonably convict someone. Another part of this amendment is no person shall be compelled in any criminal case to be a witness against themselves. This is to prevent torture. In 18th century Europe, it's a very common practice for governments and churches to compel people to be a witness against themselves. That meant they would throw them in jail, they would torture them, they would put them under stress, and then get a confession. This was seen as a very unreasonable way of pursuing the law. Government officials must find physical evidence in order to convince a jury to convict a person suspected of a crime. In order to deprive a person of life, right, they can kill you. The government can take away your liberty. They can put you in jail. They can deprive you of property. They can take things away from you if you've committed a crime, but only with due process of law. So there needs to be an established process that the government follows in order to take a person's life, to take a person's liberty, and to take a person's property. That process is more often than not established by the legislature, and then the executive branch must follow it. No person shall be deprived of private property for public use. This is the concept of eminent domain. So if the government wants to build a road across your property, if they need it for something, they must provide compensation for that seizure of private property. They can seize your private property, but there has to be a process for doing that, and there must be just compensation. The Sixth Amendment continues with suspects' rights. Here, the Sixth Amendment guarantees a speedy and public trial so that the government can't just throw a person in jail and let them rot before they've actually had a trial. And then once there is a trial, the public must be able to witness the proceedings of that trial. There can be no private or secret courts. This too was common practice both in church law and in government law. So this amendment made sure that those practices could not continue. A person in that public trial has a right to confront the witnesses against him. So if a witness wants to testify against a person, they have to show up in court, and then the suspect has a right to cross-examine those witnesses and provide a way to gain information that would show that the case has no merit. Finally, in the Sixth Amendment, someone suspected of a crime has a right to assistance of counsel for their defense. In modern terms, that means you have a lawyer. So you have a right to an attorney. And if you cannot afford an attorney, the government must provide you with an attorney. The Seventh Amendment also protects people suspected of a crime. In this case, it's a trial by jury. The government cannot just make up its own mind. It must go into the community, find people who are not involved in government, and bring them in, present evidence to them, and then that jury, independent of the legislature, independent of the executive, independent of the judiciary, right? This is a people's body. The people have the ultimate say in the conviction of a criminal. Believe it or not, there's another amendment that protects suspects' rights. So if someone's suspected of a crime, there can be no excessive bail. Bail is a requirement that the government imposes to compel someone to appear before a court. So the bail is there for a suspect to appear in court. If there is increased flight risk, there's increased bail. If there is increased danger to the community, there's increased bail. So the bail must be proportional to the crime a person's accused of committing. Also in this amendment, no cruel or unusual punishments, right? So the government cannot be cruel in a punishment, and those punishments cannot be unusual. All you have to do is go read into the 18th century and look at judicial practices, and you will find a whole host of cruel and unusual punishments governments were using. In the United States of America, the punishments were meant to deter future crimes and punish someone, not to inflict damage or harm or stress. Finally, the Bill of Rights has two very generic or general amendments. The Ninth Amendment refers to the enumeration in the Constitution of certain rights. Enumeration means listing. So we've seen the previous amendments listing certain rights: a right to free speech, a right to religion, a right to an attorney. The enumeration of certain rights shall not be construed to deny or disparage other rights retained by the people. So that if a person were accused of a crime and they believed they had a right to engage in that behavior, they could invoke the Ninth Amendment, arguing that they had a right to do this, and they could present their case based on the Ninth Amendment and therefore defend themselves against what they would consider an unjust law. Now, this Ninth Amendment basically lay dormant through most of the 19th century, through most of the 20th century. This Ninth Amendment was only really revived in the 20th century, but it was there from the beginning. Last, and certainly not least, because we're going to come back to this later, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. This is probably the worst written sentence in the entire Constitution. The framers intentionally wrote poorly with this amendment. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively to the people. The best way to understand this is to untangle this phrase. The Constitution delegated powers to the United States. It delegated the power to tax. It delegated the power to wage war. It delegated the power to legislate. Right? Those are all delegated powers. This amendment is talking about powers not delegated, so it's a negative, not mentioned, nor prohibited by it to the states. So, the Constitution prohibits states from doing certain things. Right? There are certain powers that the states may not exercise. For example, the power to wage war, the power to engage in treaties. Those powers were delegated to the central government, and they're prohibited by the states. The states cannot establish a religious test for office. That power was prohibited by the Constitution, right? So this amendment is not talking about the powers delegated to the United States. It's not talking about the powers prohibited by the Constitution, right? So this is a negative. So it's powers reserved to the state or to the people. There's only one big issue that this Constitution did not talk about and intentionally avoided. So the power was not delegated to the United States by the Constitution, nor was it prohibited to the states. Well, what big issue was that? Slavery. That was the most contentious issue that could have driven the 13 states apart. Because already by the founding of this country, there were divisions among the states about the propriety or the morality or the justice of slavery. And so in order to get past that concern, the 10th Amendment was added. So since the power over slavery was not delegated to the United States by the Constitution, nor was slavery prohibited by the states, the authority over slavery fell to the states respectively or to the people. Now they could have said that. They could have just come out and say the power of slavery falls to the states or to the people. But as I've said a couple of times already, that would have been politically incorrect. And no one wanted to touch the issue of slavery with a 10-foot pole. And so in order to avoid the issue, they wrote this amendment to avoid the contentious issue of slavery, making sure that the federal government had limited sovereignty over slavery, and sovereignty over slavery fell to the states, right? This is a federal solution. Federalism is sovereignty has to be shared between the central government and the states. So the Bill of Rights were the first 10 amendments to the Constitution that placed limitations on the federal government in order to secure ratification of the United States Constitution. The Founding Fathers feared a central government, but they knew they needed a stronger central government. So they created the Constitution. This Bill of Rights placed limitations on the federal government to make sure that it stayed in check.